afternoon, everyone. This is Ms. Shivangi Sinha, Assistant Professor, Faculty Coordinator of Madhyasthta, the ADR Cell of this college. We are delighted and honored to host this interactive video conference on international commercial arbitration under our initiative of GIADRA, which has been commenced by Madhyasthta, the cell of our college. Madhyasthta, the ADR Cell, is actually a student initiative which has been established by New Law College, Bharati Vidyapeeth, deemed to be University, Pune, a year ago. Since its inception, the cell has tirelessly put in efforts to bring to its students the seminar, national panel discussions, and publishing journals, and many other ventures which we would enable to garner information about all the aspects of alternative dispute resolution. Our principal in charge, Dr. Bhagyashree Deshpande ma'am, is always a bigger and a driven support for us throughout all the initiatives we are taken apart. Recently, the cell has launched its one kind of initiative, which is GIADRA, and because of which we are here for a video session. We are pleased to introduce to our guest today, who is Ms. Jyothi Mani ma'am, who is currently as the post of manager at the case unit at Emirates Maritime Arbitration Centre. Ma'am is an expert on various fields of international commercial arbitration, and she'll share her knowledge and expertise with the students through this interactive Q&A session. The session will be hosted by Khushbu, who is the student of Bharati Vidyapeeth New Law College, deemed to be University, and also the member of Madhyasthta, the ADR Cell. The question will be put across by various students and attendees of the session. So over to you, Khushbu, and to the attendees. Thank you so much.
Thank you, ma'am. It was an honor. It's an honor to have you, Jyothi ma'am, in our cell, and today for this Q&A session. So let's begin with our first question. Our first question is from Esha, and she's asking me.
Thank you. So, ma'am, my question to you is, how does conflict resolution through international arbitration help us on a global level?
Right, as the name states, international commercial arbitration, it basically deals with the commercial disputes. You do not have, of course, you do not have criminal disputes under them. And by each law of the country, there are certain kind of disputes that is barred from being heard in arbitration. Like in a lot of countries, you would see labor disputes being heard as a part of arbitration. But in UAE, where I work, labor dispute is not part of the is not within the ambit of arbitration. It needs to go to court. So, as the name states, it's international commercial arbitration. It's private. It's confidential. You have, just imagine, you have two large companies. Two state-owned companies involved in a very large contract, and you wouldn't want to go to court because most of the court proceedings are public. And you wouldn't want the world to know that two different organizations, two state-owned entities, which are large and very well known, are into a dispute. With the matters of the dispute, the issues of the dispute, the facts of the matter, you don't want the world to know about it, and you want to keep it confidential and keep it hush-hush as much as possible. Either you settle or you fight it out, whatever it is. So what arbitration gives you is that flexibility to keep it quiet, plus it's also party-driven. So you select your arbitrators, you select the procedure, you select what rules you want it ad hoc, you want it institutional, where do you want to seat it? Seat is a big matter with regard to arbitration for enforcement of the award. I don't know how much you know about the seat of arbitration versus the place of arbitration. Have you done that part, seat versus place? You haven't. So there's a bit of difference between when you read arbitration, or when you start studying arbitration, you come to two main aspects of things, which is seat and place, which you will hear a lot of us talk because it's very easily confused. Place of arbitration is very simply like today's session. I'm holding it in Dubai, you're holding it in, I'm holding it in UAE, you're holding it in India. That's it. right? Whereas the university can be placed in a third country. Let's say the university is based out of, I don't know, Sri Lanka. But we're hosting it from India and Dubai. That's why we're having the discussion. So basically what it means is that the deliberation, the hearings, everything can happen from anywhere, from any part of the world. You can be in Switzerland, I can be in England, I don't know, Eshna can be on a yacht somewhere in the middle of the ocean having fun. A third person can be anywhere. You can be absolutely anywhere. And you can have your proceedings, and that doesn't affect, as long as you have good connectivity, that doesn't affect the dispute at all. However, when you go to the seat of arbitration, that's something entirely different, because the seat of arbitration is, one, it's mentioned in the contract largely. Two, the impact of the seat of arbitration is that the supervisory court will be based out of the seat of arbitration. Now, if I say that the arbitration is based out of Dubai, the supervisory court for the proceedings would be the Dubai courts. Right? So apart from that, you have a thing called governing law, which is entirely different. So if I say that the arbitration, I'm having the hearing, it's very normal for us to do. In international arbitrations, what you would notice is that arbitrators sit everywhere because they're international. One is in Switzerland, one sits in England, the other sits in Singapore, different time zones. And the seat is Switzerland. You don't have to be there physically present. You don't have to be physically present in the seat to hear the arbitration, which is a very good thing for international arbitration. If it's a court case, you would have to you have to be physically to be present at the court, or your legal representative or whoever has to be present at court, which is expensive. So what makes it easier is that I can do a video conferencing like this through Zoom or Skype or WebEx. We largely use WebEx, but you can use WebEx and have the hearings. It's so cost effective versus the court, where you have to be there for every proceeding. Every documentation has to be provided in whatever language is required. International arbitration is largely English. Having said that, they do it in all languages. If somebody comes to me tomorrow and says, no, I want an arbitration which is run in Arabic, I will give it to them, provided I have jurisdiction over the matter. So there's nothing that the arbitrators do which is beyond what the parties want. So it's largely and mostly driven by the party. So what happens is that when it comes to international disputes, whatever the disputes are, I mean, it can be a small dispute like a property dispute, or it can be a large commercial dispute. What it does is that it gives you a lot of flexibility, including you can choose your own arbitrators. You can choose the so-called judges who decide on the matter. So which you can't do at court. You can evaluate the arbitrator's capabilities, their skills, their readiness, their availability, the conflict of interest. You can check the conflicts, and then you can be happy with who are on the panel, and then you can proceed with it. If you have an objection to the other person's arbitrator who's being appointed, you can have an objection to it. You can raise an objection, which all of these is not available at court for you. In court, you go by, it's a framework and you just go by that. So that's why international commercial arbitration is really, really beneficial for large commercial international disputes. But having said that, you do have smaller disputes as well. Eshna, was that clear for you?
I think it's like much more clear than what the students have got insights. Even it's much more clear to me as well. So yes, of course. Thank you for that particular answer.
If it's too much of information, you need to let me know so that I can like slow it down a little
No.
more.
It's perfectly okay. Eshna, okay. I think your concept was much more clear, because actually I got my concept clear. Eshna, are you there? I think she had some connectivity issues. Shweta, can you
Yeah, I
take
think it's
over?
back.
Yeah.
Yes, ma'am. Okay. Moving further, so our next question will be from Shubhra. Shubhra, please go ahead.
Good afternoon, ma'am. My question today is that what constitutes the drafting of an effective international arbitration agreement?
So an arbitration agreement is, to me, drafting an effective arbitration agreement is I call it an art. Because in my career, my limited career, I have seen different kind of arbitration agreements, which has actually made me cry. When I get the case, I've opened it and normally what we do in arbitration centers, it'll be funny. I don't know if the other arbitration centers, people who follow, would agree with me. I know one person who would agree with me is somebody who had spoken in your panel previously, Harold Chappell. What we do is when we get the agreement, we flip it over immediately, right? We check the first page. Okay, what's the contract? Does it match the application? We flip it over and we go exactly to the dispute resolution clause, which we call it the boilerplate clauses, right? So there, when we open, that's the fun part for us. Okay, that starts as case managers, that's the fun for us. That's where our fun begins. And I call it fun because I take extreme, each case of mine is my baby. So I take extreme pleasure in dealing with each case of mine, no matter how complicated they are, how annoying they can be, or how complicated they can get, and how much they've made me cry. I mean, cries, and literally they've made me cry on the phone saying like, please stop it. But an effective arbitration agreement is something which can be very simple, which states, which clarifies if you want to have an ad hoc arbitration or institutional arbitration, which clarifies the seat, the language, the number of arbitrators, the governing law, if you can put it in, or if it's mentioned somewhere else in the agreement. What else? Any other requirements that you need of the arbitration, or anything of that sort. Now, arbitration agreements can be multi-tiered. Actually, not arbitration agreements, dispute resolution agreements can be multi-tiered. You would see agreements such as which goes from negotiation to mediation to arbitration, or you would see agreements which go from mediation to arbitration. So there are multi-tiered, or there are ones which are just direct arbitration agreements. So it can be just a 2-line, 3-line, simple, short, crisp arbitration agreement, but you also have ones which are a paragraph long, which have time limits in them, which says, oh, if a party does not appoint an arbitrator within 21 days, it no longer is a 3-member tribunal, it automatically becomes the sole arbitrator, and the party who's appointed the arbitrator first becomes the sole arbitrator of the case, and the other party loses their right to appoint. It turns on its head in those times. So from a 3-member is flipping to a sole arbitrator, and it becomes a problem of, is it equitable? Is it just to both parties just because a party did not appoint? Is it fair? How long can you push it? How far can you drag it? Of course, each party would want their right to appoint an arbitrator, nominate an arbitrator, if it's a 3-member tribunal. But the parties' agreement is what we go by. So what happens largely is that when people draft their arbitration agreements, if the agreements are not drafted by lawyers or commercial people who understand what it takes to have an arbitration agreement, or if they're not very well versed with the arbitration agreements, or they don't just adopt a model clause. Like each institution has a model clause, and it's like a fill in the blank paragraph that we have. We say just copy paste this and just fill in the blank. That would make a simple, short, clean arbitration agreement. Everything around it can be worked around. Now, what would happen is that you would see a one-liner arbitration agreement saying, oh, if there is a dispute, parties will go for arbitration. There's no where, there's no when, there's no how, there's no seat, there's no number of arbitrators, there's no institution, there's nothing. There's literally nothing in it. So what will happen is that there will be back and forth with the courts to further define the arbitration agreement. It's clear that the parties want to go for arbitration. That's clear. However, where will they hold the arbitration? How will they hold it? Who are the arbitrators going to be? How are they going to be appointed? There's no information. However, you can also have arbitration agreements which names an institution which doesn't exist. Like I had a case where it said Dubai Arbitration Centre. There's nothing called the Dubai Arbitration Centre. You have Dubai International Arbitration Centre, you have the DIFC LCIA, you have the Sharjah Arbitration Centre. Oh, fine, it says Dubai, so let's stick with Dubai. We have multiple. You have the Islamic Arbitration Center in Dubai. You have about 4 or 5 arbitration centers in Dubai. So which one would you go to? And which one would take up the jurisdiction? So if they filed with one arbitration center, it's not necessary that the other 4 arbitration centers do not have the right unless both parties have agreed to it. So it's a very difficult, yet it's an easy thing to draft an arbitration agreement if you know what you're doing with it. Having said that, you also have to keep in mind where the parties are located, where the enforcement is going to happen, where are the assets located of the parties, what law you want to use, what seat you want to use, what's most comfortable for you. So a lot of things come into play when you're drafting an arbitration agreement. But the easiest way, I would say, is if you're going through an institutional arbitration, each institution has its own model clause. Just follow it, fill in the blank, keep it simple, no-brainer. But if you want to make it like really complex and give me a field trip, give me hours of scratching my head and finding out how to deal with it, then you can always draft a 2-paragraph arbitration agreement, which each person in the institution or any institution, I'm sure we all enjoy having those complicated ones, because personally, I keep a record of the different kind of you can't take it down, but a kind of memory, it leaves a track of what kind of different arbitration agreements that you see. And when I'm talking to people like you, I can give you an example of what a bad arbitration agreement looks like, and I can say avoid it, because it's not worth it. You're wasting time and money by doing that.
Okay, thank you so much, ma'am, for that.
No problem.
Can I have the next question, Ashruti? Next question, please.
Yes, ma'am. So my question is, who is an umpire in the arbitral process, and how does the appointment of an umpire take place?
Okay. The umpire is a very, very rare scenario that I have seen. I recently read a case. I don't know if it's old or new. I don't know. I don't even remember where I read it. But the thing that caught my eye was an umpire was appointed. I like the jargon used as an umpire, but an umpire is somebody who is appointed over the entire arbitration panel. Right, so we have a 3-member arbitration tribunal, and an umpire is appointed over them. The appointment of the umpire depends on the arbitration agreement, but it's very rare to see something like that. I have barely come across, I mean, I have not had an experience of appointing an umpire or a case where there was an umpire being appointed. It would be interesting if any of the other arbitrators have come across it. But recently I read a case where an umpire was appointed, and I would assume that it is one of those very, very complicated cases, very large, complex arbitrations where there is a requirement of another person who needs to sit on the tribunal, not as an arbitrator, but as an umpire, who is on top of the arbitration panel, dealing with the arbitration as such. So that's an umpire, which was very interesting for me when I learned arbitration in my master's. I never knew there was something called an umpire till I started my master's. And I was like, oh, there's somebody above, who can actually sit above the arbitration tribunal, and the court comes above them. So it's interesting.
Well, thank you so much, ma'am. This indeed was an insightful answer, and I guess even we were not very much aware of the concept of an umpire. So the next question is from Satakshi. Satakshi, please.
Yes, ma'am. And my question to you is, what is the liability of the arbitrator in a dispute?
Well, the liability of the arbitrator would be the first liability of the arbitrator comes when they agree to take up the case, when they agree to sit as arbitrator on the case, or they accept their appointment or the nomination. Most of the time they do something called they have a duty to disclose. Disclose as in that they're independent and they're not conflicted with any of the parties. They're not conflicted with the legal counsels of the parties. They're not conflicted with the subject matter of the dispute. And this duty of disclosure goes all the way till the end, till the award has been rendered and notified. I mean, the award has been rendered and then their mandate is over. And they have to be independent, and any disclosure that they feel is important to the case and is detrimental to the case has to be disclosed. And these are, there's actually something called the Iba Guidelines of Disclosure that is largely used. Now there are Prague rules as well. So usually we used to follow the Iba guidelines before the Prague rules came, and now there's a mix of both. But that's the basic duty of the arbitrator, that he needs to be independent and he needs to be conflict-free. Now, the next thing that he would have to do is devote enough time to the arbitration, because once you take it up, it can go on for 6 months. Excuse me, it can go on for a year, it can go on for 2 years, 3 years, 5 years, 10 years. And God forbid it goes on for 10 years. There are arbitration which has gone on for 10 years, but they are largely like state-owned arbitrations or something of that sort, which goes on for really long. I've had arbitration which has gone on for like 5 to 6 years, but they've been dormant in between because of court cases and stuff. But the arbitrators remain on the case. So when the case is reactivated or removed from suspension or it restarts, the arbitrator, they have to provide time, without which the arbitration cannot go forward. So the other thing that they have to provide is time to the arbitration. Is that a liability? No, it's more of a duty of an arbitrator. The arbitrator also has to be understanding of the subject matter. Again, that's a duty, not a liability. Largely, the liability of the arbitrator would be disclosure, that is being independent and being conflict-free. That's where a liability would come in. And also the liability of an arbitrator would be if they go out of their mandate during the proceedings. It does not affect the arbitrator as such. It has more of an impact on the award, on the arbitration award. That will not affect the arbitrator. It is just that they're going out of the mandate. The two things that can actually affect the arbitrator itself, the arbitrator him or herself, is if they're found that they're not independent, or if they found that they have a connection, or if there is a conflict of interest that on the arbitration they're sitting on. Like I had a case where a party nominated its general power of attorney holder as an arbitrator. You can't do that because the arbitrator holds the general power of attorney for a party to the dispute. You cannot appoint him as an arbitrator just because he's your general power of attorney holder, or, oh, I know him, so he's going to do it on my favor. No arbitrator acts for a party. The arbitrator, though appointed or nominated by a party, does not act for the party or a party or any party. The arbitrator is appointed to decide the matter on the case, no matter who appoints the person, court appointed, party appointed, third person appointed, however it's appointed. It's not that, oh, I appointed a nominated an arbitrator, so he will rule in my favor, or he will present my case to the tribunal. No, that's why you have legal representatives. Your lawyer, your legal counsel would do that. They will present your case. But an arbitrator is like a judge who would sit, who's conflict-free, who has his hands off, does not take sides. They will never actively guide a party towards, push them in a certain direction if they are not able to get an answer, or they will try their best to try and get an answer out of you. However, they're not going to push. If you can't do it, that's it. You can't do it. If you lose the case based on that, there have been a lot of people who've lost cases based on that. And it's really sad that happens. But it's just that you can't do anything. I mean, when I meet arbitrators after the case, I sit on some of the proceedings. I used to sit on some of the proceedings if the parties allow. And halfway through the hearing, you start realizing, saying, the party who's winning is not performing effectively, or there's a small evident question that wasn't answered, or the tribunal, you see that the tribunal is trying to ask the party a certain question and the party is going a different direction, because of which there's a slight confusion that's happening. And if that was clarified, it would have been much easier, much sooner. But there's only so much that, though you're like I wish I could do something like poke you and say, that's not what you're supposed to say. But there's only so much that arbitrators can do. It's just that. It's just that. But again, if an arbitrator is found to be helping a party, like if I was an arbitrator and I was like, no, I keep pushing a party for a certain answer and I keep guiding them to that answer, over a certain point, until it's very, it's not siding towards a party, or I'm not helping the party too much, it's fine. If I give both parties the same kind of treatment, it's fine. However, if the other party can always challenge me based on that, saying like, oh, it kind of looks like the arbitrator is taking that party's side because the arbitrator is guiding the party a bit too much. So that's a conflict. It can look like I have somehow a relationship with that kind of a person, or so I have a soft corner for that person, or I'm just siding with that person because of whatever reason. There need not be any reason. It just could be that out of interest, the person is doing that, or usually arbitrators don't do that, but it can always happen. There is a possibility, there's a tiny little chance that it happens, and the other party picks up on it really fast. So even otherwise, parties do pick up on little things and they do challenge arbitrators based on it. But again, it's for the institution who decides, if it's the court or if it's the arbitration institution who decides on the challenge, for us to see if the challenge is valid. if there's indeed a conflict of interest that's happened, or if there is a disclosure that has been missed, or is the arbitrator trying to avoid something, or is the arbitrator absolutely clean, which is most of the times the arbitrators are usually clean. The parties have misunderstood something that has happened, and that's why the challenge is happening. Challenges are sometimes a delay tactic from the party, the defendants or the claimant, whoever is on the slightly weaker side. They kind of use delay tactics to try and get more time, which is normal. I think we do that even at courts. As a delay tactic, we try and use something that's allowed to delay or whatever. So the basic liability of the arbitrator would be conflict, disclosures, independence.
Ma'am, the question is, what is multi-party arbitration and how did it take place in Arthur Andersen case?
Now, Arthur Andersen case is something that I found as a footnote in my arbitration textbook. There is one book that I got during my master's, which I follow with, I think, all my life. It's slightly outdated edition. I think there are more editions that come out after that, but that's the book I follow. That's the book I was given by the university. And there's another book that I follow by Mr. Gary Vaughan. That's a 3-volume edition. He keeps having new editions. He's releasing a new edition. And I happened to come across the Arthur Andersen case in the footnote of my textbook. The funny part is the Arthur Andersen case, the decision came in 2000, if I'm not wrong. It's one of the big consulting firms, the big fives, which was involved, and it was Arthur Andersen Consulting versus, just a second, let me just pull that out. Yeah, it was Andersen Consulting Business Unit member firms versus Andersen Business Unit member firms, right? So what was funny is that at some point, because it was member firms, there were about 33 or 36 or 34, some 30 odd parties involved in it on one side. And a multi-party arbitration is basically you have more than one claimant or more than one respondent, or you have more than one claimants and one respondent, right? So they could be involved in the same agreement, like one agreement where there are 3 parties versus 3 parties, or 1 party or 2 party. Or let's take an example of I'm buying an apartment in, I don't know, someplace in India, and I decide to buy the apartment with my mom, with my sister, so with 3 parties, myself, my mother, my sister, versus the developer, right? So 3 claimants. If I sue the developer, that's 3 claimants versus 1 respondent. Now let's say the developer at some point adds another party to the dispute as a defendant as well, because he is somehow, that defendant, that new party is somehow involved with whatever issues I'm raising or I'm claiming. So that becomes 2 defendants. So basically, multi-party arbitration is multiple parties involved. Now, this could be 1 contract, this could be 10 different contracts. However, there are different conditions under which you can bring multiple contracts into an arbitration. You can bring new parties into an arbitration. You can bind different parties into an arbitration, making it a multiple party arbitration. There are very, very different conditions for a multi-party, multi-contract consolidation thing. So in one arbitration, you can have multi-party, multi-contract, and consolidation and joinder. That's when you go absolutely crazy. So if it's a simple multi-party contract, it's good. I remember having a case where I had 30 30 respondents or 28 respondents and 1 claimant. And the number of letters I had to sign was not funny. Every day I had to sign letters, and the one thing that did good was my signature got better. So my signature is the same now across all pages, no matter how many times I sign. So it is, I mean, it was still paper back then. We're all moving digital now, so it saves me a lot of time. I don't have to do so many letters. However, what happens is that, you know, there could be a slight difference in the name. There could be a slight difference in, you know, private limited company versus, you know, a defendant could be a private limited company with the same name. There could be an LLC. There could be a I don't know, a different type of free zone company. But just the slight differences in the names can make them a different party because the composition is different. But they're all under a holding company or they're subsidiaries of a different company. It doesn't matter. I mean, you have like crazy amount of combinations that you can have for a multi-party dispute. So the basic bottom line is more than one party on each side or on either side. It's not 1 versus 1, it's more than 1 versus more than 1 probably.
Thank you so much, ma'am, for this very insightful answer.
You should
Moving
read the Arthur
further,
Anderson case. It's something that I love.
Yeah,
It's
I will.
absolutely, I think all of you should have a look at it. I'm sure Shivangi will be able to explain the facts to you better. It's actually interesting to see what happens after the judgment was released and what happens to the company after that. I mean, that was like a wow moment for me when I realized what happened. You should actually read it. And then it
After
will
your
all,
answer, we
it's
will.
all names, the names are very, very well known. You wouldn't know Arthur Anderson because it is an old company and it doesn't exist any longer, that firm specifically. But you should see what happened after that. That's what is interesting.
Definitely, ma'am. Definitely, ma'am. After your answer and your very well explanation, all of us will eventually go and read the case. Moving ahead, we have Tanmay with us. Tanmay, please go ahead with your question.
Yeah.
My question is, how are the foreign arbitral awards enforced upon in a dispute?
Foreign arbitral awards enforced upon a dispute. I think foreign arbitral awards just enforced. Is that the question? Enforceability of the foreign arbitral awards?
Yes. I think he meant enforceability of the foreign arbitral awards.
Right.
So you should I repeat the question?
No, it's fine. Foreign arbitral awards are usually something that you see. That's why it's international commercial arbitration, because you have foreign arbitral awards, which plays a big part in it. It's largely enforced under New York Convention, Article 5. It's like when you read when you taught the Constitution in law school, the first thing they ask you to do is by heart the preamble and recite it. It's like that, Article 5, the New York Convention. You just by heart it. That's what you swear by when you have an international arbitration award for enforcement. It's very interesting if you read the New York Convention, what we all use for enforcement of international commercial arbitration awards. Now, there are a couple of funny things that can happen when you enforce an international commercial arbitration award. There was a case which the award was rendered, and if I'm not wrong, it was the seat was Switzerland, and the award went to Swiss courts for the award was challenged. Basically, one of the parties wanted to have the award nullified. The award went to the Swiss courts, and for some reason, it was found that it was against the public policy of Switzerland, and the award was nullified. Now, the award was nullified in Switzerland, right? So it pushes back the parties to where they started. There is no arbitration. You know what null and void is. There's no arbitration that's happened. The arbitration award's cancelled. Everything is cancelled. So what do you think will happen if I were to take the same award, which has been nullified by the Swiss court, and take it to a different country where the party has an interest, and I feel that I can seize more, I can see some assets, I can get something out of it. So I have an arbitration award, which was, I tried to enforce it in Switzerland, it was nullified, now I'm taking it to a different country. Do you think it's enforceable?
Not really, ma'am.
Not really.
That's where arbitration throws you, it is. So the same award was taken to France and it was enforced. Because it was not, whatever was against the public policy of Switzerland is not against the public policy of France. So it doesn't matter. They saw it as a normal case and they enforced the award.
So, ma'am, does the question of jurisdiction does not arise?
No, the jurisdiction, what is the problem with the award's rendered? You have the judgment in hand, right? It went for enforcement in Swiss court. The Swiss court found it against, or whatever, it was challenged in the Swiss courts. They found it against the public policy. It was nullified. Now, the other party was smart enough to understand that probably in France, there was something that they could seize, or I don't know what was there in France. They took it to France and had it enforced. Smart. I think that person was clever to do that. Instead of throwing up my hands in the air and saying, oh my God, I lost the case, though I won the award. There was like, oh my God, like maybe the guy has something in France. I don't know, maybe he has a chateau in France or something that was, attached. Who knows what was attached, but it was enforced. The basic thing is that though it could be against the public policy in like in the UAE, anything to do with gambling is against the public policy. Okay, anything to do with alcohol is against the public policy. However, in another country, it's not against a public policy. It could not be, maybe it's not against the public policy or has any problem with the laws of that country. So for them, it's a normal dispute. Here, it's not. So if it's nullified here, they would take it to a different country where the person has assets and have it attached. Unlike a court judgment. But you can't do it. You just can't. Your hands are tied. What do you do? So that's when New York Convention comes in all glory, and you take it to a different place and have it enforced. But you need to be like any other convention. You need to be a party who is signed to the convention and all of that. And like any other UN conventions, the normal conventions, the country should have signed to it, the country should have ratified it, and all of that.
Thank you so much, ma'am.
Thank you.
With this, I hope Tanmay has, not only Tanmay, all of us have clarified our doubts with this very insightful session. Thank you so much. I would like to call Shivangi ma'am to take over.
Yes, thank you so much, Shweta. I really want to thank you, ma'am, for coming across and answering all the sessions and all the question answers so properly, so nicely that it just got into each one of us head, including me. And in the today's fast-changing world, we call a close partnership between the countries regarding the international dispute. And I really think that the study of international commercial arbitration is one step towards this ultimate goal. So I really thank you, Jyothi ma'am, for being a part of this session and guiding us throughout this, understanding this particular field so nicely. And in closing, I wish to express my gratitude to all the participants for their full cooperation, to the attendees, and last but not the least, our principal in charge, Dr. Bhagyashree Deshpande ma'am. Though ma'am is not here with the session, but eventually she'll be just looking into this. And yes, of course, thank you once again, Jyothi ma'am, for making our initiative grand success. Thank you so much,
No
and have a
problem.
good
Thank
day.
you. Thank you. Thank you to the principal of the university as well.